there's a new Chief Justice. First of all, before we even talk about the new Chief Justice, what did you think of the vetting process?
I have issues with the vetting process, not just in recent times, but before. This one was a little even lower than the standard, if you ask me. So there were two rival contentions. There's a minority leader who wants to make a statement before the vetting process starts, and he says it's in accordance with parliamentary practice. Now, I don't remember that the practice is to literally denigrate the nominee and the institution he represents, because when I didn't watch the whole thing, but I saw justices of the Supreme Court sitting behind him, and I saw other respectable people sitting behind him, and you start by calling him a disputed nominee.
We gather to vet a disputed nominee for office of Chief Justice of Ghana.
Now, where is the dispute?
That alone you thought was not called for?
It was below the belt, because it was a platform in which positions were not equal. He had no obligation to respond to that, and nobody could respond to that for him. Why is he disputed? Is he disputed because somebody else ought to have appointed him, or because somebody is in court? The court is not the court proceedings right now have nothing to do with the vetting process. It has nothing to do with the president's constitutional power to appoint somebody to fill a vacancy.
So there are two things. There were court proceedings going on regarding the removal.
Yes, but there was a removal.
Yeah, there was a removal. Yeah.
Nobody could deny that. As a matter of fact and of law, there has been a removal.
Okay.
Challenging the removal process has nothing to do with the president's power and duty, obligation to ask Ghanaians to ensure that that vacancy does not stay the way it is. And so you cannot call him disputed, because he is not disputed. Who has disputed that appointment? It doesn't lie in the power of anybody in this country to dispute it, because the power is vested in the president. He has exercised it. The dispute lies in whether the removal was proper or otherwise. If anything happens, the law has ways of dealing with it. After all.
But you don't believe there was a dispute?
No. What was the dispute? There was a dispute regarding the correctness or otherwise of the removal. But as for the appointment, there can be no dispute.
Okay.
Because the power vest, was there a vacancy, or is there, no, we cannot now ask whether it's there, because there's a new Chief Justice. At the time that the vetting was taking place, was there a vacancy? As a matter of fact and of law, that was presumed to be the position, irrebutably presumed until it is reversed. And so if you say a disputed, it's wrong at every level. And so I could understand the majority leaders' interventions and reaction to the premises upon which the other side was proceeding.
Honorable Minority Leader, just hold it a second. Yes, Honorable Ayarga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. My objection is founded on content of speeches. I have heard the ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. 1, 2, 3 says, a member shall not raise any question. 1, 2, 3, 5. A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. Apart from that, Order 1237. 1237 says that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object.
So that was my first observation, that you are allowed to make a statement, but what is the history? Do you denigrate the nominee? And I'm not saying it is because this is the head of an arm of government. I'm saying any ordinary person like me, if I appear before Parliament for any reason, if you require me to appear before you, you must show me respect. You can't start by speaking to me only because the states and the law has given you a platform which allows you an advantage that I don't have. If you want to exhibit the character or the stature that you say you have, let's meet outside your forum. But when you take advantage of a statutory forum, it is not because you are better than anybody, and to literally be denigrating people who are older than you. And I'm saying, even if you were older than them, it is an unequal platform to match a one-on-one.
Is it a semantics issue that the word disputed was not accurate and something else could have been said? Maybe
I'm not about to correct what should have been said. What I'm saying is that it's not semantic. It's not even legal. What was the position? Why was the nominee disputed? Who can dispute that? It's not as if there are two institutions or two individuals or two powers in this country who can appoint a chief justice. There's just one man who can do it. Under what circumstances can he appoint one? He can appoint one when there is a vacancy. Was there a vacancy? Yes, as a matter of fact, there was a vacancy because the person was removed. The fact that you are challenging the removal does not in any way displace the fact, the fact of law that you have been removed. And I'm saying at every point in time, people go to court to challenge a parliamentary election, a presidential election. So we won't swear the person who has been declared in office because somebody is embarking upon a gamble of probably overturning the election one way or the other. At the time that you are challenging it, the law and the fact is that the person is the rightful owner of the office. So at that point, what was the dispute? So it was not only disrespectful, it was not also properly communicating to Ghanaians what the true circumstances and facts were. And so we are dealing with, apart from the fact that they are public officials who must, in communicating with the public, at least present to them what the truth is. You are allowed to do politics. But is that the kind of politics that we want? It led to so many other things on that same day. Apart from the disrespect to the nominee, it even went further to affect another justice, the most senior justice of the day, Justice Puaman, who was the chairman of the committee that recommended that the Chief Justice be removed.
We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship Gabriel Scott Puama to trial the Chief Justice amounted to a travesty of justice.
Chairman.
To some extent, I would blame Justice Kwamang. Because as I have said, I think I've said here or somewhere, that his own report is the problem. The minority leader was one of the reasons why I petitioned, or my client petitioned for the removal of the Chief Justice. There was a huge count which mentioned his name and mentioned the acts that formed the basis of our petition. What was this count? We said he had set a precedent, in fact, a record in the court by being the only party or being the only person who within 2 hours was able to get a full panel of the Supreme Court presided over by the erstwhile Chief Justice to give him orders that by the scope of the application before the court, no court in the world in the common law jurisdiction will give him. Now, in the course of all of those proceedings and after, people who knew the two of them spoke to me and they said, don't you understand? That is his sister. The removed Chief Justice is his sister. When
Sister in terms of
Ghana,
really?
they come from the same place.
Okay.
1, 2, when her father died, the minority leader hosted her visitors, and people who were there called me. So in some of if I had attended the next proceedings, the next person against whom I was going to raise that objection was the Chief Justice. I said, all of these arguments we are having back and forth, and you are literally descending into the arena of conflict, is because somebody that you are close to is the plaintiff in this particular matter. Who was the plaintiff? It is Afenyo Markin. 2, there is now information coming out that there are services being rendered in the judicial service which are linked to Afenyo Markin. So
services being rendered?
Yes, certain services. I don't want to give all of those details because I have it, but it shouldn't look personal between me and him, that he's rendering those services and getting commercial profits from them, and huge ones. And so at this point in time, when Afenyo Markin is making it look like, okay, there's a national public interest aspect of all of this nomination process, and there's some dispute and all of that, it has nothing to do with a minority position. He sold it out to his colleagues to believe that, well, we all have to take a collective position against this, but it is a personal interest.
So in other words, you say he roped in the party, but the agenda is nothing to do with the party as a whole?
If you ask me, yes. And I'm saying that when we petitioned, there was every evidence to show that insofar as that aspect of our petition against Afenyo Markin was concerned, there ought to have been a definite finding on it. 1, we said there was no basis for the speedy fixing of that matter for hearing. Her response, and that is documented, is that no, there was a basis. And her basis was that, look, I had already issued a directive to the effect that election matters should be expeditiously dealt with. Question, was this an election matter? No. It was about cross-carpeting. So factually, that's not correct. Legally, it's not correct. 2, she attached that her directive, and this is a lawyer and the Chief Justice. When she attached the directive was dated December 2024. This case took place in October 2024. So as at that time, there was no directive. So it was clear that this was a person who was doing a personal favor. There was no rule of law. It did not even accord, there was no practice direction according to her. Her principles on the basis of which she fixed it, the circumstances didn't exist. And she plainly lied in her response. Why was that not a basis for her removal? That the person who represents justice in this country can literally look at us, lie on the face of her own paper, only because she wants to justify a position she's taking to favor a particular individual. And that individual now wants us to believe that, oh yes, there are real and genuine reasons why we shouldn't be having a vetting. And because of who we are, we haven't checked. That look, seriously speaking, we don't see any dispute here. And so the facts that we have show that you have an interest in her being there. And so he's crying louder than every other person because he has an interest in the woman being there. If we interrogated all of the counts upon which we petitioned the president for her removal, you see that they would have sustained.
Why were those grounds left out?
Yes, I'm giving one of the examples. That in Afenyo Markin's case, the committee ought to have found, and that's why I'm now saying I blame Justice Bawumia. If he had made those findings, he wouldn't be sitting down there saying, oh, and then even Justice Bawumia did this, he's a beneficiary and all of that. Justice Bawumia is too much of a legal luminary to understand that the position of Chief Justice is not his automatically. And so was even Justice Bafuboni. That upon her removal, there was no contract, no law, which said that they will be the next. So why will they be doing that only because they intend to benefit? When you sell that out to the public, you are not being honest. Because we have just seen in recent times that the most senior justices have been ignored and other people appointed. Why is it that these people who have been there and have seen themselves being ignored in favor of others would believe that removal of the Chief Justice would be to their benefit? It clearly doesn't make sense. But when they sell it out there, it goes out and resonates well with certain people because there's the sense that, oh, some people were interested, they just wanted, it's political and all of that. Kwaman, Kulendi, all those existing justices, none of them has a guarantee. In fact, the Chief Justice doesn't have to be a justice of the Supreme Court. He can be taken from anywhere at the bar. There's no requirement that the next Chief Justice to be appointed, or even the one that was just appointed, ought to have been a member of that court, of the Supreme Court. No. In fact, they could have taken the person from the Sécret court or the district court and appointed the person Chief Justice. So why were they doing this to favor a government when they had no contract with the president that, well, if you remove her, I'll give it to you? And if that was the case, Bawumia did it. Bawumia was the chairman of the committee that removed her. And I'm saying that the removal actually took place because there were laymen who understood this thing in simple context. That how can a Chief Justice be doing all of these things? If it were left to us lawyers alone, all of these arguments that don't even add up or make sense to the ordinary man would have.
So the issue that the thing was in certain courts, ECOWAS court, and she had filed certain petitions and so the court should wait to hear from them before the appointment.
And the e-levy case, what is the final determination of the Supreme Court on it? Before it was implemented and we were paying, who was Afenyo Markin in Parliament at that time? There are so many of these cases that have been pending and things have happened and people have moved on. And so pending cases
cannot affect these decisions like that.
At all. He knows better than that. I'm saying that there have been several cases pending. I took Soyine has a case pending for close to 10 years now involving ratification of mining leases. That case has never been called from any year up to now. And his point is that there are some mining leases which have not received parliamentary ratification, and the Supreme Court has determined that without parliamentary ratification, you don't have a mining lease. Those companies are still mining very well. Does he know that? And a case that has been thrown out already several times, we must wait because the position of Chief Justice is a personal one for the person who thinks they are better suited for it, and for those who think they will benefit from it, that position. It's clearly everything. I didn't think was right. It was not fair to the Ghanaian public at all.
You mentioned in the beginning that you have never really been a fan of the vetting process, but this one in particular had reached an all-time low.
Absolutely.
What is the process supposed to be like?
Now, if the process is supposed to judge the competence or otherwise of the person to occupy a position, you find that there are all types of questions that do not relate to what the person is coming to do.
Thank you, Mr. Chairman.
Are you a Catholic?
A staunch Catholic.
Ah, okay. Do you have a firm belief in the rosary, the power of the rosary?
Yes, Mr. Chairman, I have one here. Yes, please.
You brought your rosary?
Yes, please.
Are you familiar with St. Francis of Assisi's prayer? Do you pay your tithe in the church? They have your records of tithe pay?
My dues, yes, please.
You, regularly?
Yes, please.
So, who is the parish priest there?
You are talking about the Chief Justice, who mainly performs administrative duties. The reason I will side with this Chief Justice, or I will have voted for him, is because he has spent a number of years on that bench, right from the lowest level to the highest level. He has seen the administrative problems.
I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a justice of the Court of Appeal. Before then I was 6 years as a High Court judge and 7 years as a Circuit Court judge. If you look at my CV and if you follow the trajectory of my career, I was actually I actually was made a Circuit Court judge by Chairman Rawlings. Then I was promoted in 2000 and I was sworn in together with Secretary Gyamfi. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Akufo. Then to the Supreme Court by President Akufo. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rawlings, Mills, Kofo, and then Mahama, I think I deserve the position, that's why.
He can say he was a driver's mate, or he can say he was in a subordinate position and couldn't influence them. He has at least a year right now to show us signs that with all of that wealth of experience, he's been able to set in motion certain things that people can benefit from. The removed Chief Justice came with all types of policies that she alone could boast about in respect of their success. Oh, there are clear-cut rules that say when you file a process, the next stage is this, and the next stage is this, and the next stage is this. She comes to say, look, there are new rules. This case will be fixed for hearing only after certain steps, ignoring the clear-cut, the rules made by Parliament. She had power to ignore them because she says, I'm implementing reforms. What did it result into? Simple applications for 6 months in the Court of Appeal and in the Supreme Court. You wouldn't get them heard or fixed for hearing. Oh, Identity Court will sit morning and afternoon. For what? How many? Somebody should show me. I wrote against it, first of all. Somebody should tell me what it achieved. It only disorganized people's lives. Because you wake up in the morning and then your case is in the afternoon. In the afternoon, it's not even started. You go in the morning. The morning, which knows that it has to close by 12 or 1 in order for a new one to come. 10 o'clock, the person hasn't started. Hasn't started to deal with any case. So the process was not really geared towards new Chief Justice. People are complaining about justice delivery. People are complaining about adjournment of cases and all of that. Tell us practically what the issues have been. Tell us exactly how we can tackle these problems. Because when I started practice, judges were writing in longhand. They were very effective. Their cases moved faster than today when judges don't have to write. They say things are electronically recorded. A motion for joinder takes you 2-3 months. Something that in those
days, they were writing in fast longhand,
and I'm saying
things were moving.
Oh yes.
Wow.
I'm saying in those days, before you even got up to move a motion, the judge knew the basic principles, had read it, and the lawyer needed only to focus on specific issues that will sway the judge's mind one way or the other. On some occasions, joinder, injunction, stay of execution. These are things that judges would dispose of in those days very easily. 6 months, a lot of them, they are still sitting down there. Those are the things I expected to hear the Chief Justice respond to. Are you even aware of them? How many lawyers have you spoken to in connection with the justice delivery system, and to tell us what their frustrations are? Have you received any petitions? What are they in respect of? What do Ghanaians want to see in the justice system? He must have seen some all through these years. Let's have a practical interaction so that we can hold the Chief Justice to some of the things that he says. You know, but we are all over the place. You are vetting somebody for the position of Attorney General, and he has to dance Agbaja.
The Agbaja dance, do you know how to dance it?
We dance in my side of the Volta region. We do not dance Agbaja. We dance a couple of them. We have Akpi. Do you know Akpi? Then we have Bobobo. I believe you know Bobobo.
So, honorable nominee, we are here to learn about our country. Kindly demonstrate the Akpi dance a bit, just for a second.
Honorable nominee, the question is overruled. You are not going to demonstrate.
To show that you can be Attorney General. It's that Minister for Culture.
Yeah. So basically, it's not just the CJ vetting that you have a problem with. The whole vetting as a.
I think they should look at this whole idea of prior approval. That the Constitution didn't say vetting. It said prior approval of Parliament. There ought to be another way of. When they look at your CV and they've done your background checks, if they are calling you for any vetting, then there are specific areas they want you to clarify. Otherwise, Parliament should do an acclamation and you go. And then if you go and you can't deliver, your appointer is there, he will sack you. Yeah. But they keep all of us glued to television. And we are sitting down there and watching a process that 95% of is a joke.
Did you have the benefit of any secondary source of income?
Mr. Chairman, I'm married to a very industrious woman.
No, I don't get it. Please explain.
I'm married to an industrious woman.
Okay, so please explain to her. If you say you are married to an industrious woman and that is the source of your secondary income, what exactly do you mean?
I mean, my wife takes care of me.
Very well.
It is.
Yeah, and
it
so
it is. Really?
and then you are going for vetting, and your village people will come, and the party people will come.
Yeah.
And then what is that for? Is it a popularity contest? You know, there's no sanctity and respect even given to the whole thing. I don't want to be going for a vetting and a group of people are following me and all that. Pray for me. Support me with ideas. That will make it more worthwhile. But you realize that it's all a thing. Oh, are you coming for the vetting of your minister? Are you coming for the vetting of this person? What am I going there to do? Would I answer a question? No. What is my wife coming there to do? To do what? Coming to give yourself pressure. Say, oh, that's your husband. Can you talk to him about this? My family members have come, so you now know all my friends. Say, oh, talk to him about this. You give pressure to yourself for nothing. The job is for you to go and do. You are not going to do it.
How do we change that? Because this thing has bothered me for a long time. I always thought the vetting process was so useless, for lack of a better word, or so not focused. You know, why somebody's being quote unquote vetted for position, and you can ask them about what they like for breakfast?
Yes. Well, I don't know whether I want to change the system because I've not been there. I'm not a politician. I haven't been vetted before. I haven't been nominated before or anything. So I wouldn't know why they do that. But I'm talking as a Ghanaian citizen. That it doesn't add anything to my life. And I don't benefit anything from that process. And I don't see how, at my level, if I think it is useless, other people, I've read constitutional law. And so if I don't find it useful, or the kind of process that has been put in place to satisfy the constitutional requirement of prior approval, of what relevance it is to the ordinary man, and how it ensures that quality people are put in those positions. If I don't see its relevance, I'm sure other people too don't see it. So if this is my criticism, they are the ones in it. They should reassess, because I vote for them. And so they should look at it again to see how.
We should change it so we can put the pressure on who.
Well, there's a constitutional reform system going on right now. And I'm sure you know some of them. Tell them that seriously, let's look at this prior approval thing and all of that. It's a theory of separation of powers that requires it. Okay, the president has exercised his power of appointment. Let the people's reps also see whether that is the kind of person they want. But tell me, seriously speaking, where is the filter?
Yeah. It's just like a formality.
Yes.
The minute you sit down, well, I want to start by congratulating you for blah, blah, blah. Yes. So it's like a done deal.
Yes. So maybe if you congratulate the person, it's just a mark of respect to the person. But when you start by denigrating the person, only because you are in a particular seat, it's not right. If you welcome him, fine. But now let's go straight to business. We know A, B, C, D in your ministry.
So moving forward, now we have a new Chief Justice and so on and everything. What do you expect or hope to see?
I think I've told you about a few things, that the standards expected of him from me are higher because of the fact that he's been through the mill. He has worked with all of the judicial service staff at different levels. He has also encountered parties at different levels. He has even shared our experiences, his experiences with us, how he sentenced some people to 70 years for A, B, C, D reasons.
In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone.
It means he's learned a lot from it. Let's see how it impacts his new policies. Now, and the 70 years and all of that, although they are sentencing regimes and everything, in today's theory of criminal justice, is it the right thing to have done, regardless of his fears and all of that, which should not even feature in deciding whether somebody goes for 2 years or 3 years. Those are irrelevant. So he's learned all of that. Ghana has a lot to benefit from that experience. Let's see how he uses it. When I was a student, I read a number of cases in which I assumed that the cases were Supreme Court cases, because I saw Apalu CJ, I saw Akufo Addo CJ, and I assumed they were Supreme Court decisions. They were High Court decisions. What happened? The Chief Justice descended to the High Court to sit there and decide cases. What could probably have informed that? Maybe he wanted to have a first-hand experience of what is taking place in those courts. I want to see a system where the checks within the system, in the judiciary itself, would begin to correct some of them. Like, I would advise, for instance, that look, some of the superior court judges, during the weeks that they are not sitting, regardless of their schedule, the Chief Justice should assign them at random and at very short notice to the presiding judge of a particular court. Because you see, when we all sit in a particular court for long, we become like monarchs. Let him just go there and say, oh, this morning I'm coming to take your motions. And for a superior court judge, Supreme Court judge, when it comes to the High Court, injunctions and all of those petty interlocutory applications, in 1 hour, he will dispose of them. If he looks and says, this matter last came up 3 months ago, and this has been pending, why? Those judges will begin to sit up. And so there's a lot he can do. He has the experience, and we all know his CV has confirmed that.
I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus, I've been a Supreme Court judge. Before the 11th of June, for 2 years, I was a Justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge.
So there's a lot of expectation, as far as I'm concerned, on that Chief Justice. And so let's see how he implements it.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.